Our next panel focuses on the future of international arbitration, global trends and the role of the courts. Trends evolving for practices as the role of courts continue to play in cross-border disputes. This session is moderated by John Lowe, and he's a mediator in France. Welcome, John.
Thank you very much.
Our distinguished panellists include Hamish Munro, marketing commercial consultant at 3PB Barristers.
Hello, Hamish.
Really good.
Ravindra, Kumar, partner of Gunnercooke UK. And Joseph Nisa, CEO of Nisa Law Firm in Canada. And Sahar Abi Rafeh, partner of Dr. Mohammed, Almuhanna and Partners, Saudi Arabia. Please warmly welcome them for their panel.
Hello, Sahar. How are you?
Oh, which one do you want me to use?
Either, you pass them around.
Okay. We will get started and move along pretty expeditiously since we're probably running a little behind. But I'm very, very pleased with the panel. I've had discussions with everybody, and I think we have a very broad topic, future trends in dispute resolution and arbitration. So it gives us lots of room to talk about what we want to talk about, which is exactly what we're going to do. What I'm going to do is I'm going to set out a general topic and ask each of my colleagues to maybe speak about 5 or so minutes on it. And then we will ask each other additional questions, and we will also invite questions from the audience to make this interactive and interesting for everybody. I'm going to start with, and please feel free to embellish what I describe because I'm going to be very short with your description. But Hamish is the Director of Marketing and Development at a Barristers chamber in London. He has held a similar position with several law firms throughout his career. And as a marketing and development person, he has sort of a front row seat into what is happening in the world of arbitration, particularly with an English bent, but probably I would also say with an international bent. So I think what we'll do is let Hamish start off by talking about what he sees as current trends in arbitration, where things are developing, what sectors, what jurisdictions, and anything else he might think is interesting. Go ahead.
Great, I'm going to stand over here. The first recommendation I have for you is to look at the 2025 White and Case University of London study. They interviewed about 120 people and took responses from about 2,500 people in the international arbitration industry. It's 14 years of consistent study into the trends and forecasts for international arbitration. A very good read. And if you're into reading exciting topics in international arbitration, the other one is the Freshfield study, which looks at international arbitration and what's up and what's down and all the rest of it. So as John has said, I'm going to try and cover a very broad spectrum, which is which areas of international arbitration are up and which jurisdictions are the most interesting and developing. So the first thing is, well, what's up? So all of these studies are showing certain areas of work as prolific: construction, mining, transport, and energy. And the really exciting new areas of international arbitration are sport, family, and space. So I'm going to talk a little bit about those in a moment. But that's a sort of very quick summary of where the interesting new areas of work are. Those studies look very carefully at the jurisdictions where they're most prolific. And Singapore, Hong Kong, London, they have tended to dominate. The new and interesting areas are Brazil, where there's a prolific increase in arbitration, the Middle East. I'm going to turn this off, actually. I have quite a long, I have a barrister's booming voice, so I'm going to try and rely on the booming voice without the microphone. It's all right, is it? At the back there, you can hear? Yeah, excellent.
If you can't hear him, scream at him and tell him to speak louder.
Yeah. Okay. So, I've talked about, so the interesting areas of quite fast increases of work are the Middle East and Brazil. So I would, that we are seeing a significant increase in both those regions. Beijing and Paris has always obviously been strong. I'd like to talk a little bit about those specialist areas that I mentioned. The big increase we are seeing is renewable energy disputes, an increase in the commercial and public international disputes in that field, an increase in government investment disputes, the EU foreign subsidies regulation disputes, a lot more of those, bribery and corruption in the oil and gas energy fields in particular, and disputes involving Russia. Russia obviously has a new rule which essentially says we're going to ignore international arbitration, and we have a rule which allows us to effectively overrule that in our Russian courts. So there's going to be a lot more sort of fight over Russian companies' arbitration issues. I mentioned space disputes. That's around satellite launching, space exploration. There's actually quite a lot of work in America, the UK and Europe and other jurisdictions, very specifically around space disputes. Sport, the launch of new leagues has triggered a significant rise in sport dispute work in the arbitration courts. So to definitely have sight of that. Engineering, procurement, construction contracts, EPC, moving to their management thing. There's definitely an increase in the complexity of construction contracts under EPCM rules. So I would advertise that to you. Family disputes. So the British courts, just to give you an idea, we currently have 70,000 family court cases in delay. So the British family court system, the judiciary, has said our solution to this is arbitration and mediation, non-court dispute resolution. So one of the fastest increasing areas of law in our country, and is currently proposed in a whole series of Commonwealth countries, is family arbitration, particularly for divorce cases, but also for private law children disputes. So we think that is going to be a major area of development. And if you talk to the family courts, that's what they say too. If you talk to the judiciary in the Caribbean, they think this is a major step change, the introduction of, or the future introduction of arbitration rules in the Caribbean, because disputes are taking too long and are costing too much money. So that's my tip for the top. Family law disputes, sports, and probably a lot more difficulty on construction. For the lucky barristers, we also have another role for ourselves. So not only are we acting in arbitrations as arbitrators, we also will sit as neutrals in construction disputes where we are the judge. So it's a separate role, and that is a very fast increasing area for British construction specialists. The one caveat I would give is that there seems to be increasing demand on the British bar to adopt sort of commercial conflict rules, i.e. somebody from your own chambers cannot appear in front of you in such a dispute where you are the neutral judge. So with that as a caveat, that's me.
Okay.
I'm done.
Thank you very much, Hamish. We will get into questions and delve down into what you said. But since you mentioned the Middle East as a growth area, I will ask Sahar to come up and give a little talk about what is happening in Saudi Arabia. In the recent years, we've seen the establishment of the Saudi Center for Commercial Arbitration. And frankly, we've seen some major changes in the philosophy of the Kingdom of Saudi Arabia government towards arbitration. So let me ask Sahar to expound on that.
Hello everybody.
You can stand up if you wish, or you can sit down.
Sorry, 1 second.
Okay.
Okay, I will be sitting down. I think it would be easier for everyone. Let me introduce myself. Sahar Abi Rafeh. I'm a legal partner at Dr. Mohammed Almuhanna law firm. We are one of the fastest growing law firms in the Middle East. Hopefully, soon enough, we will be leading the legal field. Hopefully. As I come from Riyadh, so I will be focusing more on the new law that has been issued in 2012, and it was amended in 2017. My focus will remain at the Middle East and Riyadh specifically. So when it comes to Saudi Arabia, we all know that during 2016, Vision 2030 has been launched. And what's the core concept of Vision 2030 basically? The core concept of this vision is to attract international investors and to diversify the economy, correct? So, when it comes to international investors, what are the main requirements that the international investors need in order to go into a country? Their main requirement is legal certainty and assurance and safety. And this is what the kingdom has realized. So accordingly, they went into one of the most impressive legislative transformation of the era, in my belief. And this is how the new arbitration law during 2012 has been created and amended to fit the international legal best practice. So why the question here? Why is the question here? How does this new arbitration law align with the international legal practice? First, let me start by saying this new law, this new draft law, is drafted in line with the unilateral model law. And this is itself provides certainty, trust that the kingdom is at the moment a very reliable seat for arbitration. So basically, what are the most specificity of this law that aligns with this international legal best practice? If we look at this new law, we would realize that it provides full autonomy for the parties. This means that under this new law, the parties have full autonomy over the arbitration process. They have the power to choose the number of arbitrators, the seat of arbitration, and the governance law. And this is something that did not completely align with the previous law, and I will come to that later on. So, moreover, what are the basics, what are the other concepts that this new law has adopted? I will be talking about the competence base, which is a very firm base in international arbitration. The fact that the arbitration tribunal under the new law is the first authority to look into the issues and all the issues arising from the arbitration proceeding. And the most important part that I will also be speaking about later on is the role of courts and the shift that has happened within the role of courts. How the role of courts have changed from being a supervising authority into a complete supporting authority for the arbitration tribunal. One of the most impressive amendments that took place is the amendment in 2017 and creating within the Chamber of Appeal a chamber that is completely dedicated for all the issues related to arbitration. And this is one that aligns perfectly with the New York Convention that Saudi Arabia has been part of since 1994. And of course, I'm going to come to the Saudi Center of Commercial Arbitration.
That's what I was about to ask you about.
So this was So when it comes to Saudi Center of Arbitration, the Saudi Center stands at a milestone. The CSCA issues first bilingual awards, and we will be talking about the Saudi Arbitration Center and specifically later on. And it provided expedited and electronic proceeding. This institution is clear proof that Saudi Arabia has built a framework that aligns seamlessly with international best practice. But as you have said, the number of cases in the Middle East in general in arbitration has been growing. So if we look at the last statistics from 2020, we would realize that the amount of court cases that has been taken by the Saudi Arbitration Center has increased from 60 for previous year and to almost 200 within the 2020 years alone itself. So this is proof that Saudi Arabia, the CSCA, has become a reliable institution for arbitration in the Middle East. So I will be stopping now, waiting for further questions.
Thank you very much, Sahar. Ravindra, we will move to you right now. You proposed a number of varied topics dealing with lots of issues. I want to start with one that you raised, which you described as the proliferation of regional arbitration centers, some of which seem to be doing well, some of which seem to be doing less well. The Saudi Center for Commercial Arbitration is certainly one of them, but we also have a couple in Africa. There's Kigali, there's the South African Arbitration Center, there's a couple others in Asia. So if you could speak about their growth, how they are perceived, whether they are taking business away from the London Center for International Arbitration, SEAC, the ICC, or whether it's sort of a growing cake.
Thank you so much. I am a dual qualified lawyer, qualified in India and here in Wales. I started my arbitration journey as an arbitration practitioner 25 years ago. And my first arbitration was a domestic arbitration before a high court judge. And I came to England for the first time for an ICC arbitration to work on. And since then, in the last 25 years, I have seen tremendous growth in arbitration sphere. When I came for the first time, England was supposed to be the leader of international arbitration, with ICC and LCIA being there. But very soon, it started to shift towards Singapore, which grew substantially as a competitor to London. And within few years, we see even Hong Kong coming up, and then Dubai coming up in the IAC, the IFC courts, and the Dubai International Arbitration Center. And then we see Mumbai Center of International Arbitration, Delhi Center of International Arbitration, even in Malaysia they have. And there are so many other sector and industry-specific arbitration institutions. Like I recently did one arbitration, which was a refined sugar arbitration. Association is RSA in London. completely online. I see the growth of these arbitration institutions not as a negative thing, it's a growth. It adds, it brings healthy competition. It challenges the lawyers and the practitioners and the arbitration institutions to compete in a healthy way. Now, and the parties have choice. When they are contracting, they have a very good choice. If the parties are from, say, India and US, and they can have an option to arbitrate with ICC in Paris, with SIAC in Singapore, with ICC in Singapore, with LCIA in London. So we have choices, and all these institutions are competing with each other very, very effectively, and the practitioners are also growing. So a lot of English arbitration practitioners have moved to Singapore. The chambers have set up in Singapore. And in London, I was reading a report yesterday, is still leading the arbitration sphere. Paris is doing a lot on ICC matters because of ICC being seated there in Paris. So I would say it's a very healthy competition. It's adding rather than diminishing or affecting the growth of arbitration in the area. That's from my side.
Want to add anything? No.
Okay, thank you, everyone. Listen, I am going to change the way we operate a little bit, and rather than have me ask questions to the panel, I do have a number of questions that I can ask. I can go on for a long time, but let me open it up to the floor, and if any of you have questions, because as I mentioned, it's quite a broad topic, the future of international arbitration. If there are specific questions or areas you wish us to delve into, please let us know. If not, I will proceed with questions for the panel. But let me first give you an opportunity to raise any questions you might have. You're from Ghana, I remember.
Yes, thank you very much. Yes, so thank you very much. It's refreshing to know that EPC contracts are one of the areas that lawyers should look at.
Yeah.
Yes, I have a question around the dispute resolution mechanism. I know some of the FIDIC books or rules makes provision for what we call the dispute adjudication process. And I think you touched on it. Because it's contractual, our course, that is Ghana, had the opportunity, to interpret it, that the outcome of the dispute adjudication board is not binding. Which means that if you go through that process and you are not happy as a party, you will still have to trigger the arbitration process. So I want to find out from your perspective, do you think it's appropriate to make it binding? Because a lot of people are of the view that it's a long winding process for you to go through that. And then if the other party refuses to abide by it, you have to go and start another arbitration process. Thank you very much.
Thank you, Liman. I'll say, see, the contract which provides for a free arbitration and thereafter giving options to parties to go for arbitration, it's just creating a tier. It makes sense because arbitrations are often much more expensive than FIDIC resolutions, and it depends on the parties. If they are not happy with the FIDIC resolutions, they have an option to arbitrate. But many a times parties agree to the resolution by the FIDIC process, and if they are happy, it brings end to the dispute. Similarly, even for we do an arbitration, and if the parties are not happy or want to challenge the award in the court, they still have an option to go to court. Although the courts are now reluctant to interfere with the awards, but in certain instances we have seen arbitrators and the courts have completely set aside or reversed the arbitration awards. So it just creates the tier. Parties are free when they are signing their contract not to include a FIDIC provision, but I think it makes sense for them to have an early or possible resolution without recourse to the second stage of dispute resolution. It's beneficial for it to remain non-binding because it gives an option that the parties can come to a conclusion that yes, they can resolve by way of the FIDIC resolution, like mediation as well. Parties mediation so many times is not binding, and if parties mediate and trade, it makes sense to both the parties that yes, they have resolved their particular dispute. They save a lot of cost, time, and resources for the company. I hope this answers the question. Thank you.
You got nothing. Question over here. We'll walk around.
Oh, John.
So my question is a little bit more general, and it's about the future of international arbitration. So if you are starting your career in international arbitration now, take in mind all the new modern things that appeared recently, so AI, technology, how a lot of junior entry-level lawyers are replaced to some extent by AI. What would you advise people that are starting a career now in international arbitration to do to break into this field?
How much you want to take that?
I'll take a bit of it. I'm going to give a very British bar answer to that, which is that it's one of the fastest growing areas of law and practice at the UK bar, as was referred to earlier. I would massively recommend seeking accreditation and taking qualifications in international arbitration. As I've said, I personally think there are huge areas of developing law in arbitration. I mentioned family as an example. That's a very new area of growth for arbitrators. But whatever your passion and discipline is, I would seek to look at versions of that in international arbitration. Obviously most commonly commercial, but as I've said, there are a lot of other opportunities. And you can do that arbitration accreditation and qualifications, as a very junior barrister or lawyer in the UK.
Go ahead.
I'll also add that so far what I have seen is the arbitration practice has gone only up. I have not seen it coming down in the scope in any manner. Like commercial bars, so many countries they are organizing arbitration bar, where the practitioners do only arbitration matters, not go to court. And that shows the growth this practice area is achieving over the period of years.
In my opinion, as my colleagues previously stated, the areas of arbitration is increasing with time. But I would also emphasize on not just going into arbitration, but also learning more about the digitalization of the whole legal process, and AI, of course. I mean, if we look into all the arbitration centers in the world, they are all going toward digitalizing. This is one of the things that I was going to discuss regarding the commercial arbitration in Saudi Arabia, the fact that they have, in certain cases, been completely digitalized, from e-filing into issuing digital awards, going completely digital in certain cases. So my advice for the new generation who is going into arbitration, of course, go into arbitration, learn the the traditional arbitration processing, but also focus on how the AI and how smart contracts and how the digital world that we are living in right now aligns with the whole arbitration process. We need to find this link, I believe.
Thank you.
We have one more question.
First of all, thank you very much for such a professional talk. I am Mohammed from Pakistan, practicing lawyer. As all we agree that the countries, companies and people, they are heading towards arbitration in all over the world. Do you think the judicial system in all the countries is dying? Because the arbitration process, in my opinion, is more executive in nature rather than judicial. It does not have the sanctity of the judicial process which the courts have, especially in recording of evidence, exhibition of documents, cross-examination. What do you think as experts in this arbitration, that what is the future of courts in all over the world, in all countries? Thank you very much.
I'll start and then pass it on. It's a wide open question.
Yeah, it is.
Okay, thank you. It's a wide open question, and we've just discussed. I think I'm going to start, but I think everybody on the panel is going to have something to say, probably a little different. Looking at it, I'm going to look at it a little bit from what I'll call French and U.S. perspective, is there is a lot of arbitration in both countries, and frankly, the courts are very anxious to push off a lot of work, as much as work as possible. As Hamish used the family law disputes in the UK as an example. There are huge backlogs in backlogs in most jurisdiction. Countries like Greece, Italy, India have enormous judicial backlogs. They have to deal with them somehow. One of the issues that I see is how it is almost the financial aspect of it, because arbitration is paid for by the users, whereas the judicial system is paid for by the population of the country as a whole through taxes. But I think we are going to continue to see judicial actions being relatively favorable to arbitration, because they recognize that there has to be something else besides the judicial system for handling disputes.
Yeah, my example would have been the current negotiations and discussions by Caribbean courts to introduce family arbitration rules in the Caribbean. They do not exist at the moment, and that dynamic is being pushed by Caribbean courts for the reason that John has just said. So I think there is an inexorable development towards greater arbitration, because the court system says we just simply cannot cope. In Britain, that has been accentuated by insufficient numbers of judges and the retirement of judges, and this backlog issue has been worsened by that. So I would say they've got to coexist, and the courts are going to encourage it as a way of trying to see a future which has both twin tracking.
While arbitration adds to dispensation of pending proceedings, it has its limitations. It also gives confidentiality to the proceedings. So many times corporations fighting with each other do not want to go public. They don't want, if they go to court, the dispute or will go public between them. And the arbitration gives the platform where they can keep it private without anyone knowing that they are actually fighting, maybe the joint venture partners. And that's where arbitration is helpful. But at the same time, courts are required to scrutinize the award, to oversee how it is going, and more so, there are so many things which cannot be arbitrated. Arbitration can be done only for the disputes which are arbitrable. For example, criminal matters. Arbitration cannot take over the criminal proceedings if there is a threat or a murder. I doubt that can be resolved by way of arbitration. So far, we don't know the future, but at the moment, that's outside the scope of arbitration proceeding. Similarly, like bankruptcy proceedings, which has to be done by the courts. And courts need to exist, one, to resolve disputes which are not arbitrable, which are outside the purview of arbitrable disputes, and courts are required to oversee the awards and enforcement of it. Like you have seen in Republic of Nigeria with the matter, where the courts have overturned the arbitration award. It has been done in India as well, in Reliance matter. So I think they have to exist.
I don't think I can add anything. I think my colleague has covered all aspects, but I also believe exactly the same. I don't believe that the role of courts, even if arbitration proceedings are expanding and are covering more areas, but the courts will always have the role. It has changed, of course, with time. I mean, as we have previously said, the role of courts was more supervising. Now it has to play the supportive position with arbitration courts. So basically, I can see that arbitration and the traditional judicial system they don't go against each other. They go in a parallel line to achieve the greater goal, which is providing all the legal assistance for companies, for individuals, for everyone. So arbitration will still need arbitrators, arbitration tribunals, everything related to arbitration will still need the courts to enforce the awards, will still need the courts to enforce all the decisions made that the arbitration tribunal cannot itself enforce, such as seizing assets, for example. So basically, the roles go alongside together. They are not in competition. They will need each other. The courts will need arbitration because I don't think courts will be able to cover all the amount of disputes arising. And the arbitration tribunal will still need the courts to enforce the award and to look into all the matters that the arbitration tribunal itself cannot look into. So it goes hand in hand.
Something from here without a mic, and that's what I just add to because the question from my neighboring Pakistan, I would like to take this opportunity to.
Yeah, thanks. So I know we're talking about international arbitration, so we're all assuming that the world is full of countries with boundaries and borders which are clear-cut, and that then they all have their systems for arbitrators. And in fact, in that context also, India has recently set up the infrastructure, and we do have an international arbitration forum that's made news of late, and we hope that will have a good future. However, I'd like to draw our attention, the attention was to the role of localized arbitration processes. I believe there used to be something in South Africa long ago where they had to have truth and reconciliation in pockets because of, when it comes to a land dispute, or in an area where there has been a lot of other kinds of disputes, but you also have individual cases that are pending, then what you do with those. So we don't then just want kangaroo courts around the place. So then we're looking at the principles of natural justice that until the time you need to set up an election commission in an area, and then have an election, and then have a democracy, and then your courts come in. So therefore, I would recommend, for example, I mean, wishful thinking, but suppose they have Balochistan, where there's really no world and no courts as far as we know, or what they call POK, Pakistan Occupied Kashmir, which is actually India. So we have something like the statute, which I was talking about earlier. So the statute that I was talking about earlier in India, called the Forest Rights Act, it actually gives you, there's a whole section on how you can have local government to local government meetings and conciliations, and a process through which communities and individuals can stake claims on areas. So we then would have a very civilized way of expanding into Balochistan or retaking POK, and that's how I would look at arbitration in a localized fashion and in a non-violent fashion. Similar concepts may be applicable to different parts of the world, and places in Africa, or of course Russia and Ukraine, and of course I don't even want to say anything about Palestine right now in this context.
Any other questions?
Any other questions?
Okay,
comments?
I'm going to give each of my panelists
about 1.5 minutes to make comments on something they haven't forgotten to say. And if you don't have anything, go ahead, Hamish.
It's really just to advertise that I couldn't express any greater. These big studies that have been done on forecasts area of international arbitration, that sport and family and renewable energy are going to see significant rises in disputes globally in the next 2 years.
I'll say arbitration is, we should not forget, it's an alternate dispute resolution. It can never replace the traditional dispute resolution. It can complement, supplement, and work along with the traditional courts. It has been very helpful for this growth of international arbitration forums to resolve disputes which have otherwise been in courts would have taken years, because they are more focused and dispute specific. So we go for arbitration for a dispute, then that tribunal is dealing with that dispute only, and it can be fast tracked, it can be resolved in the manner which the parties in disputes would want it to be. But if they go to local courts, then it will take its own precedence. It will take time. I see that even in English high courts, which have fairly less number of disputes in comparison to India, if we have to fix a trial, it takes a year to fix a 3-day trial or a 5-day trial. But if you want to resolve that dispute by way of arbitration, we can do it within 6 months. So that's what I want to add and say. So arbitrations are good.
She has her microphone. We're learning.
They give. When it comes to me, I would want to focus on digitalized arbitration and on the future of arbitration. I mean, we are here discussing what are the future of arbitration and what's the role of courts.
Yes.
We are basically, as we know, we are an evolving world where digitalization, digital platforms, AI are taking over. So of course there's always a fear that AI and digitalization would create a breach of confidentiality, which is a basic principle for arbitration. What I believe is that we need to work towards expediting the arbitration process in a way that it should align with the digital world we are living in right now, without having the fear of breaching confidentiality, without having the fear of AI and arbitration being mixed together or standing against each other. I mean, we have to live in the future at some point.
I think we have a question.
Hello, good morning. And I'm from Bangladesh. I'm Tamanna Afrin, advocate, Bangladesh Supreme Court. I have a question. I think alternative dispute resolution is a very good phenomena for international aspect and national aspect, but there is a barrier. That means I think when I'm going to an arbitration, I feel it's very expensive. Do you have any idea about low cost? When you can catch my question? Okay, thank you.
I will start by answering this. Yes, there are lots of different financial models for arbitration. You have the top of the rung, you have the ICC, the LCIA, SEAC, HKIAC, but there are also a number of lower cost alternatives around. Again, I'm thinking in the United States where the financial institution regulatory authority is actually a relatively low cost. The AAA, American Arbitration Association, they do have special rates for consumer arbitration. But also I will note, and we're going to talk about this later this afternoon, I'm not sure actually how far we're going to get with this, but if you start looking around on the internet, and this goes to what Sahar is saying, is that digitalization, you're going to see a lot of new online ADR arbitration dispute resolution platforms. Some of them are going to be successful, some of them will not be successful, but they are going to come along, and they may actually be AI facilitated, but they will probably you know, I could see them, you know, resolving disputes for, you know, small amounts of money, 100 euros to 1,000 euros or whatever. Any comments?
Yeah, thanks. Some of the arbitration institutions, they have also the fee structure linked to the value of the claim. So it depends on what's the size of the claim, and then you can actually budget the cost. There are institutions like MCIA in Mumbai. They have a cap fee model where the cost cannot rise over a certain figure. And as John has said, there are many other institutions online. And also depends on which sector it is, because so many sectors, they have their own arbitration rules, like London Metal Association or I say Refined Sugar Association. They have their own arbitration. There are so many Chamber of Commerce, maybe in Bangladesh, they might have their own arbitration rule to deal with domestic arbitration, which may be much more cost effective in comparison to other international institutions. That's my.
Okay, listen, I think we're going to stop here right now to try to get back on schedule a little bit. But the panel will be around, so feel free to buttonhole them and ask them anything you might wish to ask them. We've certainly enjoyed speaking to you, and thank you very much for your attention. And thank you to the panel.